All right, let's talk about a law that, let's be honest, most students see as just a dry, theoretical chapter you have to get through. But what if I told you it's actually your secret weapon? I mean it. It's the master key that can unlock marks across your entire law paper, especially in those really tricky ICAI questions that are designed to make you stumble.
First, let me set a scene you've probably been in before. Picture this. You're in the exam hall. You're deep into a case study, and bam, you hit a wall. You know the specific act they're talking about, but the question is asking something the act is totally silent on. That, right there, is a classic exam trap.
Now, have a look at this. A law clearly says a court has the power to appoint a receiver. Simple enough. But then the question asks, okay, but can the court also suspend or even remove that receiver? You start flipping through the provisions in your mind, you're searching that specific law, and there's nothing, not a single word about removal. So what's the answer? Is it a yes or is it a no? This is exactly the kind of question where easy marks are lost.
And this is that moment of panic, isn't it? You start thinking, oh no, did I miss something? Did I not study this section properly? You reread the act mentally, but the answer just isn't there. And here's the thing, you're not wrong. The answer isn't in that specific law. You're just looking in the wrong place. The clue is hidden in plain sight, inside a different law that basically governs all the others.
And this is where we introduce our hero for the day, the General Clauses Act of 1897. Now, this isn't just another act to memorize. This is the law that actually helps us make sense of all the other laws.
So, what is this thing really? Well, think of it like a master dictionary and a universal rule book for all of India's central laws. It gives us standard ready-made definitions for common terms, and it lays down the ground rules for how we're supposed to interpret every single central act and regulation. Its whole job is to make sure everything is consistent and clear across the entire legal system.
You know, this act didn't just appear out of nowhere. It's actually version 3.0. There were earlier attempts back in 1868 and 1887, but on March 11, 1897, the lawmakers finally created the act we use today, really to consolidate and perfect all those essential interpretation rules into one single powerful law.
Okay, now pay close attention, because this slide has a detail that is an absolute favorite for ICAI to test. The General Clauses Act applies to everything, with one big exception. It applies unless the specific law you're looking at has its own different definition, or if the context just doesn't fit. So if the Companies Act gives its own special definition for a word, the Companies Act wins. But if it's silent, we fall back on our master key, the General Clauses Act. Seriously, remember that unless clause. It is critical.
So, when does this act actually swoop in to save the day in your exams? Well, first, just like we said, when a word isn't defined in the act you're studying. Second, it's super helpful in sorting out any conflicts between laws made before the Constitution and those made after. And third, it clears up any confusion about the exact date a law officially begins. It's basically your safety net for legal interpretation.
But that begs the question, right? Why did the government even bother creating this act in the first place? What was the big idea behind it?
It really boils down to four main goals. One, to shorten the language of other laws. I mean, why define year or month in every single statute when you can do it just once? Two, to make sure language is uniform. An affidavit in one law should mean the exact same thing in another. Three, to lay out clear rules for interpretation so everyone reads the laws the same way. And finally, four, to act as a backstop, to catch any accidental mistakes or omissions by the people drafting the laws.
And hey, don't just take my word for it. The Supreme Court itself, in a famous case called the Chief Inspector of Mines versus Karam Chand Thapar, explained it perfectly. They said the whole point of the act is to put all these common rules in one single place to, and I quote, avoid superfluity of language. In other words, it's all about making the law efficient, clean, and less repetitive.
Okay, so now that we know the why, let's get a quick map of the act itself. Knowing the basic structure helps you find the right tool when you're in a pinch.
The act is laid out pretty logically. After the intro section, you hit the main dictionary. In sections 3 to 4A, that's where you'll find all the standard definitions. Then you get to the general rules of construction in sections 5 to 13. Think of these as the grammar rules for reading any law. Now, sections 14 to 19 are super important. They deal with powers and officials, and yep, that's where we'll find the answer to our receiver problem. The last few sections just cover rules and other miscellaneous stuff. This structure is your roadmap.
All right, let's bring this full circle. It's time to go back to that problem we started with and actually solve it, using the tools we just unpacked.
So, you remember our question, right?
A court can appoint a receiver, but the law is silent on removing them. We were stuck. But now we know the answer isn't in that specific law at all. It's waiting for us in the principles of the General Clauses Act.
And here it is. The solution. Based on the principles baked into this act and confirmed in real cases like Reyerappen versus Mataviyama, the rule is beautifully simple. The power to appoint also includes the power to suspend or remove. So the answer is a confident yes. The court can absolutely fire the receiver it appointed. See? This is a perfect example of the Act's first objective in action, shortening the language of the law so you don't have to spell out the obvious.
So let's kick things off with a classic ICAI-style problem. Imagine this scenario. An act gets the president's signature on August 29th. The very next day, August 30th, it's published in the official Gazette. So when does this law actually kick in? Is it the 29th, the 30th, or some other date? Think about it, because this is exactly the kind of question where easy marks just disappear into thin air. Now, if you're kind of fumbling for the answer, don't worry, you are not alone. The solution isn't hidden in whatever specific act the question is about. The answer is in the one act that governs all the others. This is the rule book for reading all the other rule books, the General Clauses Act of 1897. It gives you all the default settings and definitions for every central law, saving you from a world of confusion. Okay, so let's start by finally answering that first question. It all comes down to the life cycle of a law, and specifically Section 5 of the General Clauses Act. This section tells us exactly when a law comes into operation. Section 5 gives us two really clear scenarios. First, you have the default rule. It's simple. If no specific start date is mentioned anywhere, an act comes into force on the very day it gets the president's assent. That's it. However, and this is the key part, if the notification in the official Gazette says this act will begin on so-and-so date, then that is your answer. The specific date mentioned always wins. So if regulations are signed in August, but the Gazette says they're effective from January 1st, then January 1st it is. Now, you know ICAI loves to test the little details, and that's where case law is super important. In A.K. Roy versus Union of India, the Supreme Court said it can't force the government to actually start a law. But then, in Altimus Rhine, the court added a but. They clarified that if the government waits an unreasonably long time, the court can step in and tell them to at least consider bringing it into force. And the Mahesh Narayan case just confirms our main rule. The start date is the day it's published in the Gazette, period. Not some earlier date when people were just drafting it. Two final, absolutely crucial points on this. First, the law does not care about fractions of a day. If an act comes into force on January 1st, it begins the second the clock strikes midnight. It applies to the entire 24 hours of that day. Second, and this is a fundamental principle of law, acts are always presumed to be prospective. They apply to the future. To make a law apply to the past, to make it retrospective, it has to be explicitly spelled out in the act itself. This is a very, very important presumption. All right, so we know how a law begins, but what happens when a law ends? That brings us to our next section. This deals with the really critical concepts of repeal, revival, and references for when old laws get replaced. So this is a big one. Section 6, I want you to star this, highlight it, do whatever you need to do because this is very important for your exams. When a law is repealed, it's not like it never existed. A repeal does not just wipe the slate clean. Any rights you already acquired, any liabilities you incurred, any penalties, or any court cases that were already going on, they are all saved. They continue as if the old law was still there, just for those specific things. And the Supreme Court itself explains this perfectly. It says the whole point of a repeal is to obliterate the act from the law books, just wipe it out. But, and here's the key, Section 6 acts as a savings clause. It's like a backup file that saves all the consequences of what happened while the law was active. Okay, here it is, a major ICAI trap, so please listen carefully. There is a huge difference between repeal and omission. A repeal completely obliterates the law, but Section 6 saves past actions. But an omission or deletion is different. This is when a paragraph is just erased from a law by an amendment. The Supreme Court, in the Cole-Harper-Cane Sugar case, made it clear that the protections of Section 6 do not apply to a simple omission. This is a subtle but critical distinction where marks are so easily lost. Following right on from that, we've got two more straightforward rules. Section 6A says that if you repeal an act that was only used to amend another act, the amendment itself stays. You don't undo the change. And Section 7 deals with revival. A repealed law doesn't just come back from the dead on its own. You have to pass a new law that explicitly says you are reviving the old one. It has to be intentional. Now, Section 8 is what I like to call the software update rule, and it's incredibly practical. Imagine the Income Tax Act refers to the old Companies Act from 1956. Then, the new Companies Act 2013 comes along and repeals that 1956 version. Does the Income Tax Act just break? Nope. Section 8 says the reference automatically updates to the new version, to the reenacted law. It's seamless. Let's move on to the next section, which is all about the practical rules of calculation. This is where you'll find the answers to a lot of those problem-based questions on deadlines, dates, and time periods. Section 9 gives us a simple but vital rule for counting days. When a period is described as starting from a certain date, you exclude that first day. Your count begins the next day. So if a dividend is declared on September 30th and must be paid within 30 days from that declaration, day 1 of your count is October 1st. And that means day 30 is October 30th. Remember, the word from excludes the first day. Here's a total lifesaver. Section 10. What happens if your deadline to file a form or make a payment falls on a Sunday or a big public holiday when the office is closed? Well, it's simple. The law lets you do it on the very next working day with no penalty. This is such a crucial, practical rule that comes up all the time. Section 12 gives us the concept of pro rata. It sounds fancy, but it just means a fair, proportionate share. Take dividends. If a company with 100 shares in total decides to pay out a total of 200 rupees, you get a share based on how many shares you own. So if you own 50 shares, that's half the company, you get half the dividend pool. Half of 200 is 100 rupees. That's all pro rata means. It's just simple proportionate math. Okay, a few quick but important rules of interpretation that save a lot of time. First, Section 11 tells us that when a law mentions distance, we measure it as the crow flies, in a straight line on a map, not by the road. Next, Section 13 is very important. Masculine words like he are automatically read to include females, and singular words like director can also mean the plural directors, and vice versa. But, and here's the key exam tip, watch out for the exception. Context is king. If a law specifically talks about bullocks, you can't just expand it to include cows. The specific word matters. All right. Let's look at the next group of sections. These explain all the implied powers and the rules of continuity that make sure government and official bodies can actually function smoothly without any interruptions. These 3 sections create a whole bundle of powers for anyone who has appointing authority. Section 14 says a power isn't a one-time thing. It can be used whenever needed. Section 15 allows for ex officio appointments. That's when someone gets a post simply by virtue of holding another office. And Section 16 is a big one. The power to appoint someone automatically includes the power to suspend or dismiss them. This is a really critical implied power. These next 3 sections are all about ensuring continuity, so the work never stops. Section 17 clarifies that the law applies to the position, not the person. So if a law refers to the commissioner, it applies to whoever is the commissioner at that time. Section 18 extends this to their successors, and Section 19 allows a subordinate to lawfully perform the duties of their superior. See? Together, they make sure the government's work doesn't just halt when people change roles. And finally, let's just briefly touch upon our last part here, which covers the rules about the rules, basically how orders and regulations made under an act are supposed to work. The key principles here are consistency and fairness. Section 20 says that any terms used in rules or bylaws have to mean the same thing they mean in the parent act. So the land acquisition rules can't just invent a new definition for collector that's different from the main act. Also, for transparency, before new rules are finalized, their drafts must be published for the public to see and comment on. This ensures these powers aren't used in secret.